Good morning and welcome to this special sitting of the First District Court of Appeal at the 8th Judicial Circuit Court in Gainesville. Thank you for welcoming us here today. We have 3 cases on the docket today. We will take them in the order that they appear. We will take a brief break after the second case and invite counsel and judicial staff to join us in the jury assembly room for coffee. Our first case on the docket today is Citrus World Incorporated versus Elizabeth Winningham. Counsel, if you're ready, you may proceed.
Good morning. May it please the court. My name is Michael Schwartz, and I represent the appellants in this matter, Citrus World Incorporated Corporation. Before I begin, I just wanted to, I'm not sure if you're aware, the partner at my firm, Juliana Curtis, was the one that wrote the briefs in this matter and was scheduled to do the oral argument. Unfortunately, she was diagnosed with COVID 2 days ago, so I stepped in her place since I was the trial counsel, and this is my first oral argument, so as the saying goes, I throw myself at the mercy of the court, so please be gentle. With that, I would like to reserve 3 minutes for rebuttal.
So noted.
The appellants request reversal of the Judge of Compensation Claims award of TPD benefits for 2 reasons. The first is that the evidence relied upon by the JCC for the award of TPD benefits was not competent substantial evidence of medical restrictions as it was relied upon or was related to non-compensable body parts. By way of history, this claim involved 2 body parts. There was an accident involved at the left knee in July of 2018 and a second accident that involved the left ankle in March of 2019. Those have been the only 2 compensable body parts in this claim. We attended a final hearing in July of 2020 where the issues of TPD were heard, as well as authorization of a surgery recommended by Ms. Winningham's IME, Dr. Fiore. In that final hearing, the Judge of Compensation Claims accepted the opinions of Dr. Fiore for work restrictions and the surgery recommended by Dr. Fiore for the left knee. The judge, though, denied the request for TPD benefits in that first final hearing based on the fact that claimant did not establish a causal connection between her wage loss and the work accident. The judge actually went even further in his final compensation order and noted that the reduction of claimant's wages resulted from her habitual offenses of organizational rules and subsequent termination of employment. That statement there shows that the judge found a causal connection between her wage loss and her termination for cause, not the actual work accident. We move forward from that point.
Counsel, can you address what is the meaning of misconduct? What is that term?
Misconduct is an increased threshold for behavior and actions in violation of company policy. We did argue that at the first trial, and the judge did not find that her actions rose to the level of misconduct, but he still denied the TPD benefits based on the fact that she was not able to establish a causal connection. When
you say increased, I'm struggling to understand what's with the adjectives. Increased, what is that based on? I mean, I don't see it in the statute, so I'm just...
So in my experience, I've seen that they liken it to the unemployment statute, where it shows that it's gross behavior, repeated behavior that rises to the level of not just violation of company policy, but egregious violation of company policy. And misconduct would be a total bar to TPD benefits. Again, that was not found in this case, but it's just a different level of behavior, an increased, more egregious nature of behavior and violation.
Well, how else to explain the JCC's determination? I mean, whether you say, well, okay, she got terminated for cause, but it wasn't misconduct. You know, if I have a job and I'm fired not because because it's a force reduction, but because I don't know, because I didn't show up to work a bunch of times, and I was sleeping on the job, let's say. That sounds a lot like
misconduct.
Misconduct, and so and it seems like the JCC thought that too originally in the original FCO.
I agree with you.
But and found that she wasn't going to get TPD on that basis. So, but how else to explain the denial of TPD in the first instance?
Well, again, I would agree with you. I feel that the actions and the way that the JCC wrote an order was going right toward misconduct, but he stopped short of granting it. And the explanation is that while he didn't go as far to say it was misconduct, the claimant still had a burden to prove a causal connection between her wage loss and the accident. In that case, she had work restrictions, which the employer was able to accommodate. She had 3 separate light-duty positions within her restrictions, which showed her continued ability to earn wages in excess of 80% of her wage. And the reason for her wage loss was because of that termination for cause, albeit not misconduct according to the JCC, but that was the reason for the wage loss. There was no causal connection between the work accident and her wage loss. It was the termination for cause.
Well, is the JCC's determination, and I'm not fully on board with the idea that the JCC expressly, just said it wasn't misconduct, but even if the JCC says, okay, she's not entitled to TPD because she was terminated for cause, but it wasn't misconduct, is that a legal determination or a fact determination under these circumstances?
I think it's a...
Such that, to what extent is it binding and does it carry us into this PFB?
It is binding. Well, first, I think it is a legal determination based on the facts. So it is the claimant's legal burden to prove a causal connection from her wage loss to the accident. She was not able to do that, and the judge in that first trial affirmatively expressed that the causal relation of her wage loss was to her termination for cause. That holding in his order does carry weight going forward, that the claimant now has the burden to break that causal chain of the connection between her wage loss and her termination for cause. The Wyeth case, which is cited numerous times for basic TPD elements, actually goes into some discussion at the end of that opinion about situations that we have just like this. On page 308 of the Wyeth case, and I'm going to read here from it because I believe that this is important. It talks about job search. We had a job search in that original final compensation order in a trial. Ms. Winningham employed the assistance of a rehabilitation counselor to do a job search. The JCC found that her job search was not exhaustive. She didn't take all the interviews that were provided for her, and she also didn't search for jobs outside of certain areas. While a job search is not required any longer in a TPD analysis, there are certain circumstances where a claimant can use it to prove the causal connection, and the inverse can then also be true for the employer carrier. In this case, when you have a situation where the cause of the wage loss has been determined not to be the work accident, this case says, the Wyeth case, that it is now the claimant's burden to show a superseding intervening cause to now break that causal connection to the non-industrial accident cause.
And the way she could prove that would be a job search that was unsuccessful, or that her restrictions had increased.
Exactly.
Right.
Now, to your 2 points there, first, the job search would have to be done, or could be done. That was not done in this case. She did it for the first trial, but her deposition and trial testimony after the first trial showed she performed absolutely no job search whatsoever. She was working for her boyfriend at a convenience store. It would appear that it was not somewhat formal employment. She was given some money from the cash register, products, shampoo when she needed. He gave her some relief on rent and stuff like that, but she wasn't able to quantify how much she was actually earning in terms of compensation.
But there's record evidence that she was able to work.
Correct. And I think that supports the argument, again, that the causal connection for her wage loss isn't the accident. She could have searched for work elsewhere, which she didn't do. And if the judge didn't find that the work search she did at the first trial was sufficient, arguably that was her best argument for TPD benefits. And if that was denied, there's been nothing done more since that point that would create that causal connection.
And let's talk a little bit about the burdens in this case. Couldn't the employer carrier here have done nothing? That if the claimant didn't prove that the cause of the wage loss was the industrial accident versus being terminated and not looking for work, if she didn't overcome that, there's nothing for the employer carrier to do.
I would agree with that. The only thing that I think would change the analysis in this case, if the work restrictions had increased to a point that the jobs that the claimant was doing with the employer, the light duty positions, would no longer be suitable. And in this case, that's not the situation we have. There was a lot of testimony given at the trial, at the final hearing, from Christina Gasparino, who was the employer representative for Citrus World. She testified, and the claimant also confirmed this, that she was working in a light-duty guard shack position before she was terminated. It's unrefuted testimony from Ms. Gasparino that that position was absolutely sedentary in nature. She was required to sit in a chair for 8 hours a day, and the most she would have to do was lean over a desk to check credentials of people going in and out of the facility, push a button to open the gate. Ms. Gasparino testified that they would have provided any accommodations necessary, including a golf cart to take her to and from the parking lot to the guard shack booth, even though I believe it was maybe 10 steps, it wasn't that far. They would have given her a different chair if it was uncomfortable, handrails if she needed. And again, there was no testimony that that job was not sedentary in nature. So I don't think there are any work restrictions that could be provided that would make that job not suitable any longer, barring complete total temporary disability status, meaning she couldn't work. So based on the evidence, I would agree with you. I don't think the employer carrier had to do anything in this case if Ms. Winningham couldn't show a sufficient change in circumstance with increased work restrictions to place her in a job outside that guard shack
Sure,
position.
and let's talk a little bit about the increased work restrictions and the record evidence here. So as I read this record, this claimant was awarded a surgery, correct?
Correct.
She did not have it.
Correct.
She was awarded physical therapy benefits.
That was not an award from a final compensation order. That was recommended by her authorized treating physician.
Right, but would have been compensable and paid for by the EC.
Correct.
Correct. Didn't do that.
Correct. That was not provided. Now, there is no record evidence as to why, whether it was not provided by the employer carrier or it was provided and the claimant didn't attend. There's no record evidence. But, yes, she did not have the physical therapy.
Trying to make clear that we have an injured claimant who has surgery available that would be compensated, has PT that's available and that would be compensated, and now comes to the JCC with a need for, wage loss benefits because her condition has now worsened. Is the comp system intended to compensate for that type of benefit when, other benefits that would have likely improved or at least maintained their work restrictions were, the claimant didn't avail herself of those?
Yes, to a degree, to a certain degree, I would agree with that, but there needs to be objective medical evidence that the worsening of her condition would provide increased work restrictions.
Sure, but let's just stay with that hypothetical. Where in the statute do I look to say, the claimant is entitled to wage loss because of these increased restrictions that may have been caused in part by not getting these treatments that were awarded?
I don't know if there's a statute that specifically deals with that. 440.15 is the temporary or the compensation statute, and it does show, and it's been expanded by case law, that to show a prima facie case, she does have to have work restrictions, not be at MMI, and have a reduction in her wages. But the case law, specifically Wyeth, has expanded upon that and also shown that she must show a causal relation from the wage loss to the accident. For example, if she has work restrictions, is in a light-duty position, but chooses to take a month-long vacation, obviously her wages would fall below 80%, but that's not related to the accident. That's her choice to take a vacation. In her situation, while the left knee may have progressed, she didn't have surgery, and that may have helped, she still didn't have the medical evidence that was necessary to show that the work restrictions, arguably I think they would have stayed the same. If Dr. Fiore, who was her IME, testified that barring this right knee issue, which is not a compensable body part, he would have left the work restrictions the same until the right knee became an issue. So I think that's evidence that's showing, even without the surgery or the PT, her work restrictions from the left knee would never have changed. And I think that's critical to the analysis.
Was the IME, was Dr. Fiore's opinion on this competent, even, let's assume the right knee were compensable? Was it competent based on he was making a retroactive determination during a time at which he didn't treat or observe the claimant? Tell me how that would have been competent.
I don't believe it is competent. I believe it's pure speculative opinion, and there is case law directly on point, which was cited in our brief, the State of Florida versus Martin case. In that case, there's a discussion there where a claimant had a compensable injury, received treatment, and there was a gap in treatment. And the doctor came back and received only subjective information from the claimant that the back injury was worsening and hurt. He had no medical records to show treatment in that gap or anything else, relied solely on the information from the claimant. The DCA found in that case that that was purely speculative And I believe the doctor in that case even said it was speculative, which is similar to our situation when you read Dr. Fiore's deposition testimony. He actually uses the word speculative. It requires past speculation. And when you read the substance of his testimony, it's abundantly clear it's speculative. He talks about, he did his updated IME in December of 2021. She came in and said that she had right knee pain. This is the first time she ever mentioned right knee pain. It started 5 months ago. There was no record of her receiving treatment, complaining of right knee pain to anybody, just her own subjective information about when it started. And this was vague at best. Wasn't a specific day. She didn't give detailed information about the progression and how it started, just that she had pain 5 months ago.
Was there any kind of medical diagnostic that was in the record that would have supported Dr. Fiore's opinion to demonstrate injury to the right knee?
He did do an MRI of the right knee, which showed significant pathology. There was a complete ACL tear, a meniscal tear, and some other pathology in the knee. But there was no evidence about a causal relation to that other than his opinion that it was compensatory overuse.
Let me ask another question of that, though. Before his exam in December of 21, was there any diagnostic that revealed any knee injury to the right side that would have caused any work restriction?
None whatsoever, Your Honor.
Okay.
Was there any objection to the opinion coming in?
No, there was no Daubert. There was no objection made at the time.
Was there any even objection during the deposition? Was there an objection?
There was no objection. There was a lot of cross-examination and discussion about the substance of it, but no objection was made. In hindsight, probably would have been a good option, but according to the case law from State of Florida versus Martin, a Daubert or some other objection to admissibility is not a requirement. The doctor's opinion in that case was accepted with no objection, at least according to the record. And the DCA still found that didn't constitute competent substantial evidence, as it was pure speculation.
Sure, but that's a different analysis. I mean, it's not an admissibility thing. It's more of a, the JCC is reviewing a transcript. We're reviewing the same transcript. We can each make the same assessment as to whether the opinion is any good. Is that?
Yeah, yes, Your Honor, that is correct. Admissibility or non-admissibility is not a requirement. There doesn't need to be an objection. You are still able to go in, view the evidence to show if it is competent and substantial, and according to that case law, I would submit that it's not. One of the other issues that I wanted to discuss is this causal connection between, or the lack of a causal connection between the work accident and her wage loss. Going back to that first trial, again, the judge found and explicitly stated that the reason for her wage loss was the termination for cause. According to this, and I didn't get a chance to read it earlier, in the Wyeth case, I'm talking about the job search, says, the reason underlying the notion that a job search might prove disability after a period of non-disability is that even though the employee's initial separation from employment and disruption of wages is attributable factors unrelated to the injury, if something additional is shown through subsequent events, she may be able to establish a causal relationship between her continuing unemployment and the injuries. If she is unable to make such a showing, the unrelated dismissal remains the cause of the lost wages. That's the exact situation we have here. We have a dismissal for non-work related causes, which the judge has already found was the reason for her wage loss.
Right.
Go ahead. I was going to say, you're into your rebuttal time, but certainly.
And with that, based on that case law, and I'll just say really quick here, the remaining part of that, essential to this rationale, however, is the premise that the cause of a claimant's displacement from employment and wages, once established, remains the cause unless intervening or superseding cause is established. She hasn't done that in this case, as the only work restrictions are based on a non-compensable body part. And with that, I'll reserve the rest of my time for rebuttal.
Thank you, counsel.
May it please the court. My name is Nicolette Sambus. I represent the appellee, Ms. Winningham, with regards to this current appeal. The focus is competent substantial evidence. That's the standard of review. It hasn't been disputed by the employer carrier in this matter. It is whether there is competent substantial evidence to support the judge's decision that TPD benefits should be awarded to the injured worker. This case is important to note what occurred. The parties went to a final hearing previously in 2020. At that point in time, the judge awarded authorization of a left knee surgery. The employer carrier never provided the left knee surgery. It is not a matter of where the claimant decided she didn't want the surgery. It's not a matter of the claimant not pursuing her medical treatment. They send her to a doctor who's not going to perform the surgery. That's the authorized doctor.
And isn't that being litigated separately?
There's a pending petition for Rule Nisi in circuit court to enforce the judge of compensation claims order.
Right.
So that.
So what's the relevance to the question here about TPD? I mean, this is a TPD thing. She was denied TPD originally, and now we're talking about whether she has managed to come up with a new basis for it after the JCC's order.
I'm not arguing, I'm not talking about the medical benefits. The reason why I note it is because, Your Honor, Judge Rowe, you referenced the fact that she didn't have the surgery. So it's important to note why she didn't have the surgery. It's not she's just trying to collect temporary indemnity benefits, and it's not a new reason to get the surgery. She is entitled to the surgery. It's reasonable and medically necessary. It's already been determined by the facts that it's required. Okay, so she needs the surgery. Then we go forward. She's not working. Her progression of her injury gets worse. Okay, that it's undisputed. Dr. Sando noted the objective medical findings when he evaluated the claimant for the first time in February of 2021. And Dr. Fiore, which are the accepted opinions by the judge of compensation claims, who is who is to weigh the credibility of the medical evidence. It's not
the credibility of the deposition transcripts and the paper.
The medical records, right? So that's a competent substantial evidence finding. That's not a finding for the appellate court to review. It is a factual determination based on the judge reviewing the medical records, the deposition testimony, the credibility of the claimant, her symptomatology, whether he or she finds that the claimant is credible with her ongoing complaints of left knee pain. So all of those findings, Dr. Fiore says she has sedentary work restrictions. Those are less than what, or more restrictive than what she had in 2020 when the parties attended a final merit hearing. So I'll go back to that. The final merit hearing in July 2020 related to the authorization of the surgery and temporary indemnity benefits. Now, Your Honor, you talked about the fact that the judge noted that they were denying temporary indemnity benefits at that point in time, but the finding was because she didn't establish a prima facie case for entitlement. It wasn't because she was terminated for cause. And I think it's important to note, and you'll see in the record, it's at page 172 through 177 in the prior final order, the judge outlines why she was terminated for cause. Why was she terminated for cause? Because she left her post twice outside of her scheduled shifts. So like she left to go to the bathroom when she wasn't supposed to go to the bathroom. Now she was an employee.
Excessive absenteeism twice, sleeping on the job, late, away from her workstation.
I don't, see, now, it's not sleeping on the job. It is, here, I'll go to the record. It was references to her leaving her post twice outside of her scheduled breaks, right? Then it was disciplinary actions for tardiness, leaving workstation for more than 26 minutes. These were 4 separate instances, okay? So this is an employee who had worked there since 2002. She was a employee, a great employee, there were no issues in her employment. All of a sudden she has a work-related accident and now she's getting written up for these minimal instances. The judge found it was not for misconduct. You asked what the difference is between misconduct and cause and whether that's important and whether it's relevant. Well, it's definitely a factual determination for the judge of compensation claims to make. That judge,
Based on what?
based on the standard in the statute that says that competent substantial evidence is a determination for the judge of compensation claims, and that misconduct is a determination of CSE. I think that the case law is clear that this court has already entered into that CSE is a misconduct determination. I don't think it's a question of law whether misconduct applies or cause, but regardless, that is something that's already been determined from the 2020 hearing and not before this court today. That was never appealed. The determination that it wasn't for misconduct and for cause, the employer carrier could have appealed that decision. They didn't. It was determined that if she was terminated for cause, but that the reason she was being denied temporary partial at that point in time was because she didn't establish a prima facie case. And why didn't she establish a prima facie case? The judge said because she did not establish that her work restrictions at that time, okay, mind you, at that time that were accepted from Dr. Fiore, were not enough to stop her from performing her prior regular job. And her regular job at that point was having to stand or walk for 9 to 10 hours out of a 12-hour shift. So the question, because the work restrictions from Fiore that were accepted in 2020 were that she had to take a break after 45 minutes of standing or walking. So the judge found that she didn't establish that she couldn't return to that prior job.
But what was the loss in wages at that time? That was, I mean, wasn't that the basis of the TPD claim, that she had a decrease in wages?
Right. She was terminated, the employee, the
Right.
claimant, right, the claimant filed.
And the
a-
JCC determined that that loss in wages did not have to do with her disability, it had to do with the fact that she was terminated. And now, maybe it wasn't said in those terms, but I don't know any other way to read that JCC order. It sounds like, I mean, the only decrease in wages was because she was terminated.
The standard, according to the Toscano decision, or Wyeth, I like to call it Toscano because I can pronounce that word. The standard is the prima facie case are the 3 elements, right? And the judge found specifically that she didn't meet those 3 elements. So the burden didn't shift to the employer carrier to establish a voluntary limitation of income. There's no need to get to that point. She didn't establish the elements.
Okay. Well, why don't you, I mean, put that aside and just pick up where the more recent PFE, the one that's at issue here,
Right.
Starts.
Yes.
So what was, okay, she's terminated, right? So she not working, and she's not working at the time, you know, the day after she's terminated, she's not working because she was terminated, not because of her disability, right? I mean, just as a like the beginning premise of that. The day after she's terminated, she's not having any income because she no longer has a job, she's fired. Now fast forward, and now she comes along and files another TPD based on, you know, a later date and time, a date after her termination, asking for TPD, which presumably is based on a decrease in wages. What's the causal link at that point if, looking back in time, the termination happens, she's out of work, and now she doesn't have work and she's not having any income? What is the causal link between not having that income and the original injury?
Her work restrictions. The fact that she has a,
But
Your Honor,
that's only one step. What about the part about when she can't work because of those work restrictions?
I'm getting, so let me explain that. Where I think that that is an excellent question, and the focus is not on the termination. This case is no different than if the employee leaves and relocates to another state and can't find a job because she has work limitations that prevent her from returning to her pre-injury form of work. It's no different than being laid off. This was not a termination for misconduct. Misconduct would be a bar from future temporary partial disability benefits. It's not a fraudulent misrepresentation case. It is not where the claimant is in any way barred in the future from obtaining temporary partial. So when the claimant, I know that she was terminated, and I understand that that's the terminology that's being used, but it was for cause. So now, fast forward.
What's the cause?
The cause was those 4 elements that I believe were based on 44205, where they were discriminating against her because of the workers' comp injury. But that's another argument, right? So
Well, that's another claim entirely, right? That's a retaliation claim, but we're not here to
we're not
discuss
here about
today,
that.
right?
Right, no, we're not here about that, but that's
But I
the,
interrupted you, I'm sorry.
well, no, you're right, but that's
Yeah.
the, I don't believe that that's the standard. The standard, according to the case law, is Toscano. Did the claimant establish the prima facie case for entitlement to temporary partial disability benefits? She's not barred because it was a termination. She's not barred because she was laid off. She was not barred, none of those, it's all the same.
It's not really a question of a bar, though. Again, she still has to prove that the
Right.
cause of her inability to work is the industrial accident. And here, it's not just the restrictions. It's the fact that she, can't go back to work for this employer and has not looked for any other employment.
Well,
Right?
Well, and
Isn't that part of her prima facie case?
the part of her, right, so the 3 elements, like you indicated, are A, she's not at MMI, check, not in dispute, okay. Second element, causal connection between the loss of wages and her injury, which is the work restrictions. her work restrictions significantly increased from the time of the prior final order. So we don't even need to talk about the prior final order. Actually, it's the time period that it's at issue is February 2021, the date after she saw Dr. Sando, where Dr. Sando said, okay, sedentary work restrictions, which are significantly increased from her prior work restrictions.
But
So
translate that into a decrease in wages. Unless you're saying, as a matter of law, if you have sedentary work restrictions, you're 100%, you have suffered a decrease in wages.
if you don't have a sedentary job prior to your work-related injury, according to Toscano, that establishes a prima facie case. According to Toscano, the three elements are evidence that she was unable to perform the task of her pre-injury job was sufficient to establish prima facie entitlement to temporary partial. When she can't go back to the job she had prior to her work accident, then she has established that causal connection to entitlement to wage benefits. Then the burden shifts to the employer carrier. The claimant established the prima facie case. She couldn't go back to her pre-injury job.
She couldn't go back to her pre-injury job because she was fired and she can't go back for 5 years.
No, I understand that position, but she couldn't return to her prior job because her prior job was she was working as a manufacturer operator. She had to stand and walk for 12 hours a day. Her shifts were 12 hours, and out of her 12 hours, she had to stand or walk for 9 to 10 hours at a time. Her shift at the guard shack, which was sedentary, arguably, which is what you're talking about, was sedentary, but she was terminated from that job, partly because of non-existent reasons, which the record, I think, establishes. She wasn't terminated for misconduct, but that's not where we are. We're talking about from February 2021, she was assigned sedentary work restrictions, significantly increased from before, but prevent her from her pre-injury job. That is important, the pre-injury job, that specific quotation from the Toscano decisions and the subsequent decisions by this court after that. It is not any job whatsoever, it is her pre-injury job. So if I'm a construction worker and I only can do sedentary work, have I established a prima facie case? Yes, if I'm not at MMI and I have loss of wage earning capacity. Then the employer carrier has to prove voluntary limitation of income. Sorry.
All right, so no, finish your sentence and I'll ask my
Well,
question.
that they have to prove, counsel was citing to intervening subsequent cause to break the chain of causation. It's their burden to establish that. They have to establish that subsequent intervening cause to break the prima facie case that has already been established. That's the Church's Chicken decision from 2013. It states once a prima facie case is established, that cause remains unless and until an intervening superseding cause, which would be a voluntary limitation of income, some sort of other reason that the employer carrier drums up, but that's not here.
Okay. Well, let's assume all of that is correct. Let's actually talk about the medical restrictions here. And, you know, based on the record we have before us, we have the IME in Dr. Fiore coming in December of 21. He performs diagnostic tests. He sees that there is injury to the right knee, which I think we all concede was never found compensable. Looks at the restrictiveness of that on the workability from there, and then kind of looks backwards at a time where he wasn't treating her, looks backward at a time where there's no diagnostic test that would, at least I couldn't find in the record, that would support the limitations he's testifying about. How is that competent, substantial evidence, even under the application you're advancing, of that kind of limitation on her ability to work?
I'm not advancing any factual findings that were not determined by the judge of compensation claims. The judge found that Dr. Fiore's opinions were more appropriate over Dr. Sando. Dr. Fiore opined in December 2021 that the claimant had sedentary work restrictions. And I understand that you're saying that there's the reference to the right knee, but in his testimony, it's clear that he's establishing that sedentary work restriction, or that even any work restriction at that point in time, to be associated with the left knee and then later the right knee because it subsequently became symptomatic. Now, this is not a case where the right knee was denied as compensable. It's not something where the claimant took the right knee compensability issue before the judge and the judge denied it. That's not before this court. There's no pending petition for authorization of medical care for the right knee. That's not in the record. The issue is Dr. Fiore's opinions were accepted by the judge.
Fair enough, but let's talk about those opinions a little bit more.
Okay.
I mean, even if we limit it to the left knee, how was his testimony going backwards in time? And again, the last time he opined, he testified as to particular restrictions, but now making this retrospective determination 2 years back that she would have had this limitation, back then. How is that competent evidence under the statute?
I'll analogize this to any specific case where the employer carrier denies compensability and the claimant has to fight tooth and nail to get authorization of medical treatment. The claimant has a date of accident, here it was in 2018, and then doesn't get medical care. The employer carrier sends her to Dr. Sando, who's not willing to even provide the surgery that the judge ordered. So they send her to a doctor that's not willing to provide her care, who's not giving her the proper opinion. So the claimant has to get an IME, an expert, to evaluate based on reasonable degree of medical certainty, which his opinions are, which he clarified, and he provides an elaborate, detailed explanation as to why he arrived at his conclusion. This isn't something where, like in the Martin decision that counsel cited, in the Martin case, that's a 1997 case that deals with attendant care, and that deals where the doctor solely based his opinion on, the claimant's subjective pain complaints, but also on an inaccurate medical history. Dr. Fiore had a medical history that was clear and correct. There's no dispute that he had inaccurate information. He based them on objective medical findings from his physical exam, but also based on diagnostics. So he was able, as an expert, I'm not a doctor, I like to pretend that I am, but I'm certainly not. I don't know how they arrived at these conclusions, but he was able to state with a fairly detailed analysis as to why his opinion is supported by competent substantial evidence, why he's able to say that the claimant should not have been working outside of sedentary work restrictions dating back to February of 2021. He was able to say that. He didn't say, I'm just guessing, I have no clue. He stated, I have the ability, he analogized it to a time machine. He said, I'm looking back. I get the medical records, I can, date the MRI findings, the subjective complaints of the claimant, the lack of any evidence of any subsequent intervening accident between the date of accident and where we are here today. So with that evidence, with that medical opinion, the judge, as the trier of fact, as the individual who weighs the credibility of one physician over another, over the claimant's testimony, determined that Dr. Fiore's opinions were appropriate and did support the finding that the claimant met her prima facie case for entitlement to temporary partial benefits. Do you have a question, Your Honor?
Can I go back to and we're talking about the July 30th, 2020 order. That was the original, that was the first FCO?
Yes, Your Honor.
Okay. And I've heard you say several times, and your opposing counsel, the same thing. The judge the JCC did not find that it was, intention or misconduct or something like that, hedging on the terminology. And I'm looking at it again, and I'm sorry, it really sounds like the JCC is finding that there's not a connection between her wage loss and the injury because of her, whatever you want to call it, her multiple violations of office policy, including, by the way, and he did find that she was sleeping on the job as well. That was another reason that
Okay.
On the list. And also, it says additionally, the journals show the claimant repeatedly leaving and returning the plane on several days in March. So anyway, my point is that he goes through, several paragraphs talking about the disciplinary actions and the reason that she was not making money anymore, and it was because she was terminated, and she was terminated because of these things that happened on the job. So help me understand, how are you reading the order in a completely different way?
I see that I'm past my time. May I respond?
Yes, I'll extend your time by a minute, and we'll do the same for the appellant.
I'll answer your question quickly, Your Honor. I think that that it's a good question based on the facts of the prior order, and if we were appealing the 2020 order, it would be particularly relevant. The fact that the judge determined that she was terminated for cause is important only to the extent that it wasn't misconduct and it doesn't bar her entitlement to temporary partial. The fact that she came back now for the appealed final order and asked for temporary partial from February 2021 and continuing, the standard doesn't go back to what was previously found. The standard is she entitled to temporary partial from February 2021 on? She's not asking for it dating back to the prior final order.
Sure, but to get into the Toscano analysis, you have to identify, I mean, it becomes relevant to why she stopped working or stopped earning wages. One of the sentences is, the reduction in the claimant's wages resulted from her habitual offenses of organizational rules in subsequent termination of employment. That's a finding from the JCC. So that is the reason that she originally stopped earning. And why is it not disposed of the fact that your client didn't do any job search whatsoever to establish that this injury resulted in a loss of wages prospectively after post-injury termination?
I think that is a statement in the record, but that's not the crucial finding. The finding from the judge of compensation claims at the prior final order was that she did not establish a prima facie case showing that she couldn't perform her prior regular job. That was the finding that the judge relied upon in denying temporary partial. And that's why it's relevant to the Toscano decision, because the three elements are met. She wasn't at MMI. She could not return to her prior job, partly because her work restrictions significantly increased based on the employer care not providing the medical care they were supposed to. And third, that third element that I just forgot. But anyways, I'm past my time. So I respectfully request, Your Honor, to affirm the judge of compensation claims TPD order based on CSE. Thank you.
Thank you, counsel. I'll ask the clerk to add another minute for the appellant as well.
Can you please the court? There was a lot of discussion there about misconduct in the prior final compensation order. Misconduct, I don't think, is relevant to this current analysis. We didn't argue misconduct for this current PFB and recent final compensation order. It was based on Judge Tannenbaum, as you said, that Judge Arthur, in that first compensation order, specifically said the wages resulted from her termination for cause. That is him establishing the causal link from her wage loss to the termination for cause. Based on the reading that I said from the Wyeth Toscano case, once that's established, it is the claimant's burden from there to prove some superseding or intervening cause to break that causal chain from the non-work related cause. She didn't do that in this case. The work restrictions even increased, which we still argue is not competent substantial evidence because they're based on the right knee. And it's critical that Dr. Fiore's testimony says he would not have increased work restrictions, even without the left knee surgery, would not have increased them until she became symptomatic for the right knee. So his work restrictions would have remained the same. Those same work restrictions that were in place at the prior final compensation, the final hearing, which the judge denied TPD with those work restrictions, she's shown nothing else at all to break that causal chain. And while the Wyeth case and the appellee is correct that it talks about the ability, the elements are the ability to earn wages at the prior, the pre-accident job, there's also a critical part of that analysis that says in that that she can adequately perform her prior job with the employer, and, this is conjunctive, a requirement, whether the workplace injury caused a change in employment status resulting in a reduction of wages below 80%. Her work accident didn't change her employment status. She remained employed for months, up to a year, where she was working various light-duty jobs within her restrictions, including absolute sedentary restrictions, earning in excess of 80% of her average weekly wage. Her employment status didn't change because of the accident. It is her burden beyond that, after that compensation order, where the judge found for us, he established that causal link to her termination for cause. Claimant would have, according to the case law, wasn't a requirement, but one very persuasive element would have been an exhaustive job search, showing that the new restrictions from Dr. Sando or Dr. Fiore prohibited her from finding a job in the open market. She didn't do that. She actually showed us evidence she could work. She did it for her boyfriend at the convenience store. From a public policy standpoint, you can't award TPD benefits just for, sitting around and doing nothing. I mean, the purpose of workers' compensation is to get a claimant, an injured worker, back to employment status in a reasonably fast.
And before your time runs out, again, based on my extension from asking too many questions, one last one. So when I said misconduct before, I mean, first of all, misconduct is actually defined non-exclusively in the statute. But beyond that, are you saying that Toscano is not limited to misconduct situations? It can, call it non-misconduct, call it, I guess, for cause, something short of misconduct. And I ask that not because we're talking about a bar. It just, your position is Toscano applies in any situation where the employee is terminated for some other reason. Obviously, Toscano deals with reduction in force, but is that what you're saying, that don't focus on the misconduct as a term, just focus on the termination for something other than non-cause, I guess?
And I see I've gone over my
Yeah.
time. Can I
You
respond?
may answer the question.
Yes, it's not limited to misconduct, and it's not even limited to termination for cause. It's for any reason, claimant, if she just voluntarily resigns or does something else, for any non-industrial accident cause for her loss of employment or loss of wages. And that's how that opinion goes. And with that, with these reasons, we would ask that that this court reverse the award of TPD benefits, as there was no competent substantial evidence to support that award. Thank you very much.
Thank you, counsel. Thank you both. We'll give the counsel in the second case a moment to trade places.